We've seen historic decrease in public confidence in our judiciary and the judicial system. What are the long-term consequences of that erosion of trust?
I think it's important to recognize that we've seen a loss of confidence in all of the institutions of American government. The Pew Research Institute has been doing a survey since the 1950s about the level of trust in the federal government. It's at the lowest point that it's been. Congress has the lowest approval rating that it's had. I recently saw a poll that put Congress approval rating at 16, and that might be 16 people, not 16%. The Supreme Court has its lowest approval rating. Institutions of higher learning, college universities, have their lowest approval rating. The media has its lowest approval rating. And so I am very afraid for the future of democracy if people have lost faith in the institutions of government, the institutions that really are the pillars of our society. I put the loss of faith in the judiciary in that context. But I also think that some of it is the courts have brought it on their own. The lack of an ethics code in the Supreme Court was a self-inflicted wound. And most people don't separate the Supreme Court from lower courts, federal courts from state courts. If the Supreme Court loses steam, all courts lose esteem in the eyes of the people.
What does a judge, when they are making a decision of interpretation, what does that judge actually do when they're interpreting the law?
I think it's important to separate different kinds of law because what it means to interpret the law varies. Let's take a statute. That's a law that's passed by a city council, a state legislature, Congress. All judges will start by looking at the words of the statute. Some will focus a great deal on what was the purpose of the statute. Some will look at what did the legislature intend. There's also a whole body of law that would refer to as common law. This is judge-made law. It's not based on a statute. It's not based on the Constitution. The law with regard to personal injuries. Much of the law with regard to contracts is this way. And here judges are looking a great deal towards precedent and what have courts previously decided how to apply it. And then there's the most high profile, the Constitution. And here all justices will start by looking at the text, but really do the words of the Constitution provide answers for the issues that judges have to decide? Then they'll look at a variety of other sources. What was the original public meaning of the provision? What does the structure of the Constitution tell us? What precedents are there from the court? What's been our social tradition? What are public needs? And justices disagree about what weight to give to these sources. Maybe I can put it to you a better way. In some instances, the law is clear. In some instances, the law is unclear. When the law is unclear, then judges and justices have to look at other sources. They may disagree about what those sources are, but they're looking at things like, what are prior decisions, precedents? What traditions exist in society? What are our current social needs?